So welcome everyone to this next session here at Berkeley Law, at the Berkeley Center for Law and Technology. I have two of my favorite instructors with me today. One was my boss and one was my former partner. I'll let you work through that on the outside and figure that out. But they both still talk to me, so at least I did something right along the way. So today we have Sheila Jambekar from Dayforce, one of the leading in-house thought leaders in privacy, cybersecurity. Been in that field since the beginning. Actually helped create that for several people, big, large companies, brand names by now in the Valley. And then Cynthia Cole, if you've been to any programs with me, you know Cynthia from Baker McKenzie, partner at Baker McKenzie. She's got a title too long for me to remember. Let's just put it as she is the boss. Maybe the whole firm, she might dial that back a little bit, but in terms of privacy, cybersecurity, in a firm as large as Baker McKenzie, she is the leading authority. So putting these two together, both brings together some great legal minds, and actually should be a really fun recording. So thank you both for joining. I know this is late in the day. It's a Friday that when we're recording this, and you could be doing a dozen other things, but you've given this time to us. So I really appreciate it.
Well, thank you, Wayne. I appreciate that introduction. And so you've now introduced us, so we don't really so much have to introduce ourselves. To the point of being later in the day, that'll make it all the more fun. And someone needs to hand us each a glass of wine, and this one will go on all evening, and we'll make it extra fun. But thank you again for that intro. As Wayne said, I am Chief Privacy Officer at Dayforce, which is a HCM company, a software company that does payroll and other human capital management software. And Cynthia, anything else you want to say about you?
No, I mean, just really happy to be here. Thanks for that generous introduction, Wayne. And Sheila and I go way back, and we always have a great discussion. So really looking forward to kicking this off.
Yeah, so we like to nerd out together on privacy, don't we, Cynthia? So we figure we kind of try to do this a little podcast style, a little bit more dialogue style. So we'll kick it off with a icebreaker question, and we'll start with what is your biggest pet peeve when negotiating privacy? And maybe I'll start if that's okay.
Yes. Yeah, please do.
So my biggest pet peeve is when I get asked by somebody to negotiate some privacy related clauses with zero context whatsoever about what's happening, who's the customer, or what we're buying from the vendor, and they just say, is this okay? And I have zero context. So that is my number one pet peeve. Cynthia, what is your pet peeve?
Okay. Well, so actually I have 1.5 because
Okay.
yours made me think it's very similar to when, from the outside counsel perspective, when I get the question, hey, do you have a privacy statement that you could give me?
Right. You're like, what do you guys do?
Yeah, I'm like, probably, yeah, I have a lot of privacy statements, but none that I will give you. How about that? Here's a little checklist and let's have a little, anyway. But no, my real pet peeve that I had thought about is when I see an agreement that has data, right? There are data issues, there are security issues in it. And you've got data addressed, which is related to your pet peeve, right? You've got data issues that are addressed separately, and they aren't actually thought through in the rest of the agreement. So, you've got a provision that says that the customer, that the provider can keep and use the data that they're collecting as part of the service, to do XYZ, right? But then there is a termination of the agreement, but there isn't necessarily a termination of, or there's a termination of the DPA that's attached, right? But there isn't necessarily survivability of the obligations right, that arise under the DPA, because obviously the data goes beyond, you know, once you have the data and you possess it, you have it, right? So it's when we see an agreement, and honestly, this happens a lot, right? And it's all kind of piecemeal, and the whole sort of issue of, again, like survivability, assignability, it's a little bit like a license. You know, sometimes I'll do a license agreement or I'll read a license agreement, and there's a license grant, and there's the agreement, and there's and the license is perpetual, maybe not, right? But then it's unclear that when and if the agreement terminates, the license terminates as well, right? And I see, or if the agreement can be assigned, can the license be assigned, right? It's separately. And so it's the same type of idea. And it's like, if data is at the center of the agreement, well, make sure that it's at the center of the agreement.
Yes, I think that's a good lead into our next topic or slide here, because you know, if there were a tidbit or a piece of advice for a non-lawyer or a privacy lawyer, for that matter, that you could give about negotiating privacy or data-related terms in a commercial agreement, what would be that one like key tidbit of advice that you would give? If you were to say, hey, remember this one thing if you remember nothing else.
So mine would be, get crystal clear on why you're signing this agreement, right, with this third party, and what is the data that is involved. Because the number of times that I will ask a client, right, or when I was in-house and we're looking at agreements, and you talk about the data that's being shared, no one can actually enunciate clearly what data we're talking about.
Yeah. It's similar.
It's like, it's kind of astounding.
Yeah.
That we just move
Similar
words
to me,
around.
my advice would be somewhat similar in that idea that like there's sometimes this concept that somehow the data is like a separate thing.
Yeah.
That it's, oh, that's the privacy stuff. But really, at the end of the day, every contract is two parties, maybe more, setting up the rules of the road for how they are going to engage with each other. What is it that we're exchanging? What are the rules for how we're going to operate in this relationship that we are creating vis-a-vis the contract? And when data is a huge part of it, it's the same thing for the privacy terms. You need to think through operationally, what do I want? What am I really, what's important to me when it comes to this data? Do I want them, and think through that contract lifecycle, like what data are they collecting? Then what happens? What am I going to do? How is it actually going to be to operationalize these? How do I want to allocate our responsibilities and the risks? What kind of product or service are we talking about? And what is the data that we're talking about? What kind of commitments have I made to other parties around this data? And all of that really isn't that fundamentally different than other kinds of business relationships. You could say the same thing about IP that you might be exchanging, and like, well, how do I want this to work? Do I want them to be able to give it to somebody else? Do I not want them to give it to somebody else? What are the rules if they give it to somebody else? What can they do with it? What can they not do with it? Same story with data. It's not as sort of esoteric or separate. It is just another core piece of what it is that you're trying to do in terms of setting up the arrangement. Context, then that's why context matters so much. And your point about survivability, I think, is a good one, is like, hey, did you really think about it? Do you really want that if they get to keep the data, all of the requirements around security or how they protect it or what they're allowed to do with it, if they keep it, those go out the window because those were all in the DPA that you said is now terminated? Like, really, like, it's not as complicated if you spend a little bit of time to just go like, well, what is this? What would that be like in practice? So I think that that's the part that I would say is like, don't think of privacy or data protection terms as so fundamentally different than other kinds of business relationship matters that you as a attorney or contracting commercial attorney are used to negotiating. And then of course for privacy attorneys, do the same thing. Like, don't think about what you're doing in a silo. Oh, these are the rules and I can't do anything else. This is
Right, right.
like context, and that context will help you decide, gee, am I comfortable with this or not? And maybe I don't need to follow my template exactly the way I had, because in this case, does it really matter? And so I think that would be the next bit. All right. Next,
Well,
go on.
well,
Not yet.
I was going to say, to kind of follow on to that, I think it's also a question of benchmarking, right? Like, is this the only third party who can do that, perform this service? Right. And so it's, understanding the context of like, look, maybe it is. And so you really need them. Well, I guess, first of all, you have to isolate why you're actually at the table with them, right? Because maybe you don't need them. But if you've decided that you do need them and they're the only ones who do it, well then, right, you need to prepare yourself for a certain amount of give, right?
Yeah. Well, that's just like every other business
Right.
term that you're going to have. It's not as if the privacy stuff is so completely separate. It is very much part of it. And I think it's also really important. And now I'm going down to my second tidbit of advice. I think it's important to really understand your business. And I think
Yeah.
outside counsel, like understanding like the beyond just like the context of this relationship, data, particularly personal data, there's also there's often a relationship outside of just the two of you. There's guaranteed to be a relationship with somebody and an individual.
Yeah.
So you have a relationship with an individual that you have to be keeping in mind. Potentially, if you are in a chain of suppliers, maybe you're a processor and you're negotiating with a sub-processor, you've got to be thinking about, well, what's my relationship with my customer whose data I am now sub-processing out to another vendor to do work. So that a little additional context as well is like, where does this fit into the business? And what other kind of obligations have I taken on, or is another bit. It's part of the reason why I love doing privacy, because I feel like I really got to understand how all the puts and takes come together.
Totally.
It does make it a little bit complicated. And I imagine as an outside counsel, that can be complicated as well when you don't have maybe the in-house detail that I would have for my client.
And so, well, so it's interesting because yes and no, right? So I guess one thing I was going to say too is also making sure that the obligations that you've made, like in your privacy statement or something else, right? Other public facing agreements are consistent with what the terms you're about to agree to in this relationship, right? But the other thing is that as outside counsel, again, someone who's been inside and also, just has a lot of context and experience in this space, it's actually, which makes it even more surprising that you wouldn't sort of understand this when you're in-house, but it's actually not that hard to get a pretty good sense pretty quickly of where a company stands and how sophisticated their views and their agreements and their relationship is to the data that they're collecting, right? And because first of all, you look at their privacy statement, and if it's dated, last draft, January 14th, 2021, well, then that's a tell, right? And then also just the way that they talk about the data, and do they just shove everything off to, again, looking at a privacy statement, do they just shove everything off to third-party terms, right? Like, oh, these are just the links, here are the links to all of the third parties, but there's really nothing of substance about their own process and procedure. And I think that's one of the things that we try to get across to our clients over and over again is you need to have policies and procedures in place with respect to data and the data that you're collecting and the data that you're processing. And it doesn't have to be, and it shouldn't really be like a 300-page, memoriam, right? It needs to be, but it needs to be clear and it needs to be specific, because that is, everything else should flow from that, right? And most or many companies don't have that.
No,
And-
that is it's sort of a bit to your point. It's a basic, how do you know what you want to contract for if you haven't really figured out what you want for your
Or what you do.
what do you care about? Like you have to think about what do I care about? And yeah, think a little bit deeper. Well, I think that that's going to lead us into like, what do you care about is it's a good lead into the next topic, which is a sort of a core topic, but worth reiterating is key terms, defining roles. So let's talk controllers and processors. I have had people say to me before, but we're not in the EU, so why are we talking about controllers and processors? When I've been working with non-privacy attorneys, trying to work through contractual expectations and analyzing what people are expecting vis-a-vis their role. What do you say to that, Cynthia? Do these concepts help? Do they not help? Is it important to understand this? Is it useful to understand this? Or you're like, nah, if you're not in the EU, ignore it. Where do you come out? Then we'll fight over it if you disagree with me.
Well, so I think the issue is, again, it gets back to, how do you see yourself in these defined terms, right? As a company. And if you can't, and I like to, frankly, I shouldn't say this because this is broadcast to, at least more than one person, but I do like to, and in different contexts, I like to play with having undefined terms, right? Because obviously that has benefits in certain circumstances, but here, this is the basis, right? This is the basis of, one, what your role is and what your relationship is to the data that you're collecting. That needs to be defined. And so using the term controller, right, it is a shorthand way to get clear, right, on, and it also signals to the third party, it signals to potential regulators and third parties. Everyone at this point should know what a controller is, whether you're, a US regulator or, right, you don't have to be a supervisory authority, right? So
yeah, I'm same page, regardless of whether you're in a location or even maybe you're in a place where there is no privacy law at all that's applicable, but you still want to set out the expectations. Having these at least as concepts that you understand well, to your point, it's a shorthand, it's a heuristic that in the privacy space helps us say, hey, what is my relationship to the data? In the cloud computing space, we talk a lot about shared responsibilities. This is
right.
a way of being able to talk about what are those shared responsibilities? What's your role? If I'm a controller, I understand I have a certain set of obligations and certain set of potentially in rights. I have a right to potentially define more of what I do with my data, so long as I can fulfill my obligations to the individual, more flexibility potentially to build a relationship directly with the data subject or the individual whose data it is, and then have some more flexibility of what I use the data for and making decisions. On the other hand, I have obligations. Processor, I always sort of say, like, I'm standing in the shoes of the controller and I am doing what they tell me to do. And we negotiate what are those instructions for what.
Yeah, and I wash my hands of it.
And then like, you tell me what, like, if you didn't get consent, that's not my problem. If you didn't tell your individuals that you were going to have me do this, that's not me. My job is to follow your instructions and keep it safe. And so I think that, like, understanding, again, even if you're not in a jurisdiction that uses these terms, although more and more are, California the exception using the useful terms of business and service provider. But having an understanding of what these terms mean just helps each side understand what their expectations are. And to your point, it also sets those expectations. I don't have to spell out necessarily all the details. I don't have to say this is our shared responsibilities and how we parse the responsibilities, because by using these terms, we can at least sort of bake some of that in automatically. And I think that that's important. The sort of fun thing I have to say is that, you know, understanding, are we two controllers? Are
I
we?
don't know if that's fun. Is that really fun? Actually, Sheila.
No, no, that one usually isn't, but it's an interesting thing. But like to understand that, like I what tends to happen is most often, at least in my experience in-house, most often it's controller processor. One of you is a processor, one is your controller, maybe it's a processor sub-processor. But then it's fun when you get, for me, when I'm like, oh wait, these are two controllers. Sometimes I've been in situations where we're a processor and the other party, the counterparty is actually also a processor of the same client. And so that's enough. It's
Yeah.
interesting one, right? Where maybe you're like, well, we're both following the instructions of our client and they've told us to work together. And now actually what we're doing in this contract is figuring out the terms of how we're going to work together at the instruction.
Oh, wow. Yeah, right.
So there can be some interesting, like different configurations here, but understanding that is very powerful, I think, for then okay, got it. Now I've got, which template do I grab, or what is the framework I need to be thinking about in terms of how I then move forward for this. So I reiterate, these are useful terms. These are useful terms.
They are useful terms. I mean, they are, I think they are ultimately, especially I would say processor, right, tends to be overused in the sense that oftentimes, you know, it's an entity, it's a company that's acting as a controller, and they they label themselves a processor in order to try to avoid, you know, ultimately, right. I'm just a processor. I'm not, yeah. So which again, you know, and this was earlier today, and it's so funny with drafting, just generally, right? And I see it all the time, and people want to be complicated, or they're unsure, I guess, how clear how clear they need to be, and will that give too much away, right? And I think in this space in particular, right? Clarity and more information is better. And I think even if you end up having something where, you know, you've used controller, processor, but there needs to be more specificity, which, I mean, it's provided for, right, in SECs when it is subject to GDPR. But let's say you're using those terms, but it isn't, right? You're not in a GDPR context. More specificity, more clarity in plain English is definitely worth it, because again, it gets, even if it's just for yourselves, right? It gets you to a point of clarity, right? Like, let's say even this is a little different, but I was working on an M&A transaction recently. We were talking about representing the seller and or the buyer, representing the buyer, and we were talking about some of the data, you know, that the target had, that what they had and sort of what they'd done with it, et cetera, talking about, you know, issues, potential compliance issues with the collection of that data. And then, you know, and ultimately as we were talking it through, we ultimately came to the decision that, you know what, we don't actually need those customer agreements, right? I mean, we had the sort of troublesome clauses, right, with respect to sharing of agreement of data. And I just think that's where, again, when you're willing to spend the time to have the discussion and get clear about what is the purpose of this transaction in any context, right? Then you can get clear on, then it's easier to ring fence the risk, right? And then it's easier to isolate it and mitigate it, because sometimes you can just say, oh, you know what? We don't actually want this or need this. So we
Yes.
can
We move
or-
on.
or the data is actually not sensitive at all, right? And so we're actually fine with, you know, these terms in this context because the value to the business is so great, right? So again, it's being willing to kind of have those frank and clarifying discussions, and then writing it out. You know, I don't know. I read these things about, this is a little bit of a tangent, but I read these things about how people, you know, don't know how to write cursive anymore, don't know how to read cursive, don't know how to write. They just put everything on a tablet, and how writing, the act of writing, right, is a way to organize your thoughts. And I'm a big fan, you know, but anyway, so I just think,
Write it
again,
out.
yes, write it out.
That's
Get a
what
piece-
you want to do. You know, it's interesting that you brought up the point about sometimes companies are like, well, I want to be a processor, or maybe even your customers like, I want you to be a processor. And
right.
the reality though is I find these terms very useful. However, don't think misconception I have run into is that you can just declare what you are. And
Yeah. Yeah.
yeah, at the end
Right.
of the day, they are heuristics for facts of how you actually operate. So I find
Right.
these useful heuristics to understand what are the contours of how I'm allowed to operate, but I don't get to just say, I'm a processor, if in fact I am not acting just as a processor. The thing that's interesting is sometimes like that can kind of work both ways. Sometimes you're like, well, actually, I have to be a controller, even though I'm a service provider, not in that way that that is defined by CCPA, but I am providing a service to you and you're giving your
Right.
provide a service. Maybe I have certain separate regulatory obligations, like in the financial services that can come up, that require me to actually have some
Right.
information about what I do with this data. But I think that like this is where the controller processor, people kind of then get like, I can't have you be a co-controller. I can't. And you're like, look, okay, wait. I literally promise you I will do nothing with this data except what you tell me, plus whatever the regulators tell me I have to do with it. And that usually from a business perspective, go, oh, that makes sense. That's fine. But then people kind of get wound around the wheel about but then can you still say you're a processor? I'm like, well, and not I could say it, but I don't know whether like a regulator would say
Well,
one, but I'm achieving the same goal of what you're looking for. So again, like
right. Yes.
like
Right.
you don't want me to use your data for crazy purposes and start behaviorally marketing with your data. But that's not what I'm saying why I need to be a controller. I'm not trying to be a controller, meaning I'm going to go crazy with your data. I'm saying I need to be a controller because technically I have separate regulatory obligations with respect to your data. So I think these terms can be very helpful concepts, but like on the flip side, sometimes people get a little too attached. And I would say the regulators can get a little too attached too sometimes around these words. And we lose again sight of, well, what am I trying to achieve here? I can be a controller and still actually make all the promises that you want me to. I just have this one little carve out that says, but I'm going to retain your data because I need it for anti-money laundering, kind of thing. And then people usually kind of, but the business people get over it, but sometimes us privacy lawyers get into our academic circling, we get a little out of control with it. All right. Next topic. Let's get into the meat of it. You got a DPA. We got that data protection addendum. Okay. You're a commercial lawyer. Maybe you're a privacy lawyer and you're like, okay, yep, I recognize these terms. What are like, let's dissect that data, that's classic data protection addendum, and what are those key terms that we all get hung up on. You want to grab one of these, Cynthia, to get started and dive into one of the topics. Do you want to go with should we start with order of precedence? Do you want?
Oh, that's funny. Yeah, I was looking at that one.
Order of precedence. Welcome to the order of precedence. Welcome.
My gosh, I'm
Who
going
is
to use that.
king? Who is king in this
Yeah,
content?
similar.
Yeah.
So, well, and this, I mean, this one is, again, this is another one, right? This is another one of those, frankly, they fall under in, commercial agreements, they fall under the miscellaneous category, right? Like assignment and survivability and, right? An order of precedence can be your best friend or your biggest, or your biggest foe. And I just think it is, again, it's paying attention to who, like, and it is very specific. It's specific as to who you are, right? Like, again, and what kind of data you have and what you're using it for, and then who you're sharing it with. And again, it's a question of, look, ultimately, do you want to be able to change what is in the master agreement, right? And do you think that the next sort of bite at the apple in a follow-on agreement or something that is attached as an appendix, you will have potentially more leverage there, and you could get a term that is maybe disfavorable in some way. You can get that reversed for that particular incident. Well, then, there's your order of precedence.
Yeah.
But you need to think about it.
I think it's interesting because order of precedence, I feel like is one of those fun things. If you are in the scenario where like, oh, someone just ripped this privacy notice off the back or DPA off the back and said, negotiate this. Or if you think that there's going to be those bites at the apple and you're like, they're not going to call me back as the privacy attorney again, that can be your friend because you'd be like, this thing trumps all things. Whatever I put in here when it comes to data, this thing, I don't care what else is in the MSA. I don't care what else you append. It is a little bit of like a security blanket when sometimes those additional terms get negotiated, or you're not sure, maybe you're trying to deal with the privacy stuff and the MSA is still kind of moving and you're trying to work together and you're like, okay, it's my way of being like, I don't care what you do, but this has to be true. And like these ones trump whatever else you put in that MSA. So it is an interesting one, but I feel like in some ways it can be that security blanket for you. And I that's why I often see it. It's your standard in your DPA template, which just says no matter what, this thing, when it comes to the personal data, this is this addendum is what matters. So.
Yes, and I would say too, there is also though, yes, agreed. And but what I was going to say, sometimes you see that it's got a certain specificity, right? So when you talk about, all things data, are you going to refer to a specific provision in the master, or are you just going to leave it data little d, or is it defined? So again, those are the fine points in that, right, that follow when you make a statement like that, and you want to be crystal clear on, what I mean is all the data, like lowercase d, which would seem to be the opposite, right? But when you want to go bigger, you don't define it, right?
That's true.
And so I just think it's, again, it's so tedious. It's exciting for, it's exciting for us because, well, this is what we do, but it is tedious, but it is so important. And the number of times, again, where, in an M&A transaction or a strategic transaction down the road, where someone else is reviewing these agreements, and it's really important because it affects the value, or it affects the sort of regulatory position, or it's an enforcement action, and it matters.
Yeah, it does. It does. Well, so we could probably rabbit hole down that one even further, but let's talk about a couple of other things. I'm going to grab on this grab bag of fun. I'm going to grab sub-processing and processor controller roles, the purpose of processing. So I'm going to grab those two. So provision, right? That we talked about this before. Who's a processor? who's a controller? Why are we processing this data? That's really like going back to what we were saying before. It's key provision. What are you doing? What are you allowed to do? What are you not allowed to do? This sometimes is the addendum to the addendum. Sometimes you see it as like a template, which is the addendum to the MSA, and then the back, it talks about your purposes of processing. But it's important to, if you're negotiating on somebody else's terms, what have they put in there? What are your purposes of processing? Why are we engaged in this relationship, and who is who? Who's doing what for whom? Good idea. To your point about being specific, this is where you spell out what are our roles. And then the sub-processing, this one's always fun. Are you allowed to further outsource? If I'm a processor or I'm using a processor, are they allowed to further outsource? Let's be honest. Very rarely are you going to be in a scenario where you're working with a vendor who isn't outsourcing some aspect of processing your personal, the personal data you're passing to them to some other party like AWS or Azure or some large infrastructure provider that is managing their servers. Or there's just the way that the ecosystem in the cloud works these days. We're all kind of using each other's services. And so it's a little outside of operational reality to expect that your vendors are not going to be sub-processing. This is where there's, I think, a tension between in certain jurisdictions like the EU, the regulators want and expect and demand by law, or kind of put on a controller or, you know, the party at the top of the chain vis-a-vis their vendors, and what's the operational reality. So you see this obligation, you got to ask me before you outsource or change your vendors. And so you see what companies do is they get around that by saying, hey, give me a general authorization to say I'm allowed to like choose my vendors, so long as you give me notice who they are, so long as you make
they agree to the same.
So long as they agree to the same level of protections, that you're not going to lower those protections, to try to get around this kind of idea that somehow as a controller, as the party that is then further outsourcing their services, that you're going to have this knowledge of third, fourth, fifth party risk that's going down the chain. Yes, that would be theoretically nice to have, but like operationally next to impossible. I think it's also an interesting thing as companies that are what I call middle cloud, where you are a cloud service provider, but you are not that infrastructure. Like you've got yourself, you know, maybe even bigger companies than you that are your sub processors or your vendors, and so you maybe have a customer negotiating with you who's more powerful than you, and a vendor, a sub processor who's more powerful than you. And
I mean, that's often the case.
And you're sandwiched between the two. Yes, it's very common. Probably most cloud providers are kind of in that sandwich position, and you're trying to navigate, well, I can't give more rights to my customer than I'm allowed to extract from my vendor. And so you're a bit trapped. So that's a fun one, but it is something that be prepared to understand the operational realities of what you're dealing with there. And I think being able to explain it to your customers can be helpful. I have found where customers are like, well, I want to have XYZ rights vis-a-vis your sub-processors. Or I want this or that vis-a-vis your sub-processors. Sometimes just being really upfront and being like, it'd be great, but I can't get that from my vendor. So I'm giving you the best I can in light of what I'm able to get from the sub-processors. So those two things can be a fun one, but be prepared for having to have your sub-processor list at the ready and kind of navigate like what is operationalizable vis-a-vis what your customers are asking. And as a customer, be realistic about what you can expect from a vendor when it comes to how they manage their sub-processors. And then if you are on the vendor side of that, work with your third party, your procurement teams, and make sure everybody's aware of like, hey, we've just agreed to our customers. We have to agree to let them know, and it creates an operational cycle.
Yeah.
So be aware it is not just the contract's done and then shove it in a desk, because adding sub-processors to the list is one of the most common things that you will continue to have touch points with your clients after that. And so be prepared that that's going to be something that they can see, they will experience. You've got to do it. What's the next one that you want to grab? We've hit on order of precedence, processor controller, sub-processing. Any of these you want to grab?
Yeah, I mean, cross-border transfers is like a whole presentation in itself. And I frankly see that box in particular evolving pretty quickly, right? You know, in the next few months for sure. Definitely in the next 4 years. So I think, I mean, that's like hot lava, right?
Prepared that this is going to be a topic, right?
Yeah.
Yeah. And also this feeds into the sub-processors. Where are your sub-processors? So don't just
exactly
who your sub-processors are, but ask them, where are they sub-processing your data? Do they have sub-processors in certain countries that you're uncomfortable with, or that could be a problem for your data to go there? Those things can really feed into each other for sure. And it is definitely an area I see. Just today, I was having conversations about data going to China or not, data leaving China or not. And those sorts of conversations come up.
And you know, look, and the reality is that this is a topic that has been gaining momentum, right? In the last few years. And we're seeing, you know, GDPR was not meant to be to ring fence data in Europe, but there are certain jurisdictions, there are certain companies, right, where they have taken that approach. And then as we see other regions, right, and other countries, they clearly put in place data privacy and security laws and regulations. That's clearly the motive, right, is keeping data sort of internal. But, you know, I see a number of obligations in contracts with clients where the obligation on the processor is to keep the data in a very particular location.
Yeah.
Right. That's an add-on.
And that's an add, and then this is one where I was laughing. I was like, this is where your contracts intersect with international diplomacy and politics. And
1,000%. Yep.
Right. This is that place where that's what's that can drive these things. And this is one of those, again, this is another of those areas where you put that contract in the drawer and it's not over. It's not like you pull it out next time there's a problem to figure out, well, what are the rules are. Like this one can really be impactful, particularly as we're seeing changes, right? The EU recently, I think, came out saying, hey, China might be a little bit not safe for European data. You know, obviously the US has been going that direction, concerns around data going to certain countries, but also vice versa. Like I said, China has cross-border data as well. And so this is another one of those topics where understanding your obligations and keeping track of what you have signed up for as your company grows and evolves is really important. Don't lose track of this provision, because one, it changes, but also your company might be changing, right? And again, that contrast with sub-processing rights. If you've got lots of, oh, this client says that we promise we will never process your data outside the United States. That may be today, but if you switch your sub-processor, that may become not true tomorrow. Or you just grow as a company and go, gosh, we could hire people outside the country to do this for less money. And now, wait, what violations have I created? So this is definitely an important one to keep in mind, lives on. It's not one of those that slides into the contract drawer and you hope you never see it again.
No, no. And it could also be a question of your standard operating procedure is to move data, right, to a particular location, or, that's part of your IT infrastructure. And what you've agreed to with a customer is in fact different than that, right? And you can do that. It's completely within, right, what you can do, but you just, in the implementation, you forget to do the switch.
Yeah.
And so this is one where you can see a number of inadvertent, right, violations of an agreement that you just signed.
Yeah.
And I think it also gets to security requirements, right? And that, so which is similar. You might, again, because of the importance of the agreement that you're entering into, you might negotiate something that is above and beyond what your standard, security requirements or notification requirements are. And to your point about operationalizing, have you taken note of it, and it's risen to the level where it gets communicated appropriately across the business? So in fact, what you've agreed to gets done. And then secondly, is that being operationalized, right? Yeah. And the number of companies that have come to us and said, so we've got, I don't know, 10,000 agreements that we'd like to just take a quick peek as to what our notification of incident, what our requirements are with respect to our notification of incidents. How can we do that? Well, then we start pulling out some e-discovery tools. But, this gets away from you, right, as a company very, very quickly.
Yes, it does. And you start to scale. You hope that you're signing lots of contracts. And I think it's a very common thing when companies are small to say, I'll do whatever you ask, sure, but not have also the foresight or the tooling or capabilities or, resources to say, we should keep tabs on all these special obligations that we're having, and we should keep track of them. This one, the notification of incidents is just definitely like I think every CISO and privacy person's like, oh my God, yes, please. If you're doing this, if you're setting up your procurement, if you're setting up your sales, please, somebody write this stuff down and make it so I can search it. Because in an incident, you usually have very little time to go figure out how much time you have to notify the client of the incident. If you're now going to Cynthia's firm going, I just had an incident, can you help me figure out when I'm supposed to notify? By the time you have signed the agreement with the law firm to do the work, you are out of compliance with half of those contracts, because usually it's 3 days or less, right? You're usually have a very short time, and you don't have the equipment, the capabilities to in the moment read every contract to see which one says I have to notify them yesterday, tomorrow, the next day. What is the definition of what an incident? Is this an incident under which contracts? It's another one that standardize. Do not just agree to this stuff willy-nilly unless you are fully prepared that you will probably not be able to meet the requirements in operation. Like, you just need to be like either honest with yourself, or you have to build up the infrastructure to do it. And even if you had perfect infrastructure to tell you, and I could search, who do I have to tell when? You've just made your life that much harder, because you got 5 they got to tell on this day and 100 on the next day, and 10,000 3 days from now. So standardizing in this area it's one that there's lots of negotiation on. I feel like with commercial and sales people, let's just give it away. Let's give it away. But like in practice, it's really, really hard to operationalize if you don't have standardization. And let's be honest, the salespeople and probably the people who are involved in the procurement or who are involved in the actual negotiation don't have to deal with it. So they're like, oh, it's easy for me to say. I'm like, yeah, but it's not easy for us and the security and privacy team to actually do.
Yeah.
So this one, it gets negotiated a lot. And I will say, this is another one where think hard if you are procuring, whether you really want notice of potential security incident in
Right.
24 hours or less. Do you? What is a potential security? I've had things where the way that the client has worded it because they thought it's better. They thought it's better to have more notice and stricter requirements. Like you realize that there is always a possible security incident happening at all times. If you this one was if you have suspicion of a potential security.
Oh my gosh. Oh my gosh.
Like
Yeah,
at
no.
all times, most CISOs worth their salt will be like, there is a suspicion of might be happening right now. So I think again, this is one of those like, what does that really mean in operation? And is that what do you need to have so you can check a box for a regulator to say that I got the thing? What do you really versus what do you want? And maybe like stricter, more broad notice requirements isn't necessarily going to get you a better outcome for what you need. So what are you going to do with that? Hey, we think that we might have an incident, not sure yet. You're like, great.
Right. What are you gonna, yeah.
Tell me
Well, and I think, yes, and I think that also kind of leads to liability and indemnification, right? Which is because ultimately a breach, of that or one of these other commitments that you've made is, could be a liability inducing, right? Behavior. And so again, and this I see, I mean, the failure to now liability and indemnification are not in the miscellaneous section of agreements. They oftentimes have their own little section head. But the lack of follow through that I see, right, in negotiating and in really understanding what those provisions say and what they mean, what the impact is, I think is frankly, it's astounding, right? They have become so boilerplate, right? That people skim them.
Yeah.
And they don't, and oftentimes, honestly, I mean, there was there's the sort of, I don't see this anymore, but I did see this for about a minute. Unlimited indemnification or uncapped, right? Indemnification for a breach or a security incident. Again, that lived a very small life and that is no longer the case. And those are all subject now to caps or super caps but oftentimes, frankly, what I see is no mention in the liability and indemnification sections of the agreement of the existence of DPAs.
Oh yeah, that's interesting. And I think what I thought you were gonna say was that you had been seeing people saying, "Hey, we'll indemnify you for fines or other or that would cover regulatory stuff." And
oh my gosh, I've never seen that.
No, good. There was a brief around GDPR when it first came out, where people were like, "You're going to indemnify me if I get in trouble for GDPR," and you're like, "No, I'm not, because that's 4 times your annual turnover." No. And so, but I agree. This is again like contextual. I think, yes, like the company has to limit what kind of liability and indemnity they can take on for you, but you as a customer, understand, like, what does it actually mean? I think I literally said in a negotiation the other day, what are they doing for us and how bad is it if they screw up? And
right,
it really comes down to not like how big is the contract maybe $5. And so like saying, oh, can we do 5 times the value of the contract, 1 time the value? I get that that makes sense from their perspective because it's an ROI kind
Right.
of idea, but like from my perspective, I'm like, I don't know. If I'm paying $5, but I'm giving you 100 million social security numbers to process, no. 5 times the value of the contract ain't gonna cut it. On the other hand, if like I'm paying you $5 million and the only thing that you're seeing in terms of personal data is email addresses, maybe five times the value of the contract is
Yeah.
more than enough probably for me to be
Oh,
comfortable with the level of indemnity and liability. So again, it's like not tied to the value of the contract, it's tied
no.
to the data in terms, and that's where I think you see sometimes like, oh, well, we'll just use the limitations of liability and indemnity in the main contract, but you do have to kind of think broader, like, well, what does that mean in the context of the data situation that we're dealing with? That it may be more than enough, you're great, or it may be like, no, we've got to carve out a separate, if there's a data thing, we're going to use these rules instead.
Right.
A place where
Right.
if you are the vendor, knowing what kind of coverage you have and your insurance coverage is also very helpful. To know how where are the lines going to draw. So
Totally.
all right, two last things we haven't hit on, and we'll hit them on quick. Audit rights and data subject requests. So I will quickly say, I think we can say quickly with data subject requests, if you are a processor, you're not supposed to handle the relationship with the individual. So you will probably see something in your vendor agreement with your customer that says you will not respond to these directly, but you will send them to me. Or if you do, you have to help me respond to them. If you are a controller, if you are two controllers, this may be actually an area where you really do need to do a lot more negotiation, and you really need to set up the rules about like, okay, if I get a data subject request, like how are we going to make sure that we're both doing what we're supposed to be doing here? So it's sort of it's kind of like a no-brainer template thing when you're dealing with a controller processor. These are the rules. You're going to send the information to me. You're not going to respond to these directly, and I will handle them, but you will help me if I ask you. When you're controller to controller, then this is the place where I think sometimes you're two controllers, but maybe you, depending on the relationship, you may not actually both have a direct relationship with the individual. Even though direct obligations to the individual, you may not have a direct relationship to them. So you might have a controller who has the direct relationship, and then maybe you're buying data for enrichment or something of that sort from them. If that data subject says to the seller of the data, I want you to delete all my data, how do you make sure that what are the rules for you? Are you allowed to continue using it? Are they going to pass them through? So that's actually where an interesting one, where you're two controllers, how do you handle data subject requests? Who's going to do what? Who's going to communicate? Do you want the other one to communicate? Maybe you're like, no, don't communicate with my customer. Well, I will communicate for you. That's an interesting one. You want to grab audit rights? This one can be a fun one to negotiate.
I mean, yeah, I mean, this one is one, it is, but it should be, it's table stakes, right? I mean, I think you should expect you should ask for audit rights, you should expect them, you have them, right? Under certain circumstances. And, but again, you need to think about what that means for you and what is actually, attainable and important. Are you going to be exercising audit rights like every 2 months and you're going to ask for all the books and records or all of no, right? You're not. So be realistic, be real about what it is that you need to know, and then focus on that, right? And a lot of this also gets to, some of these things are a part of, their key provisions, and they're not going to change, they exist, and they've got
the regulator. Maybe in the case of the EU, the regulator requires you to have something in there about that. And
but oftentimes, that's not the case. And so you're negotiating, and so what do you need to be sort of horse trading again, given your leverage and importance and, you know, where are you in the sandwich, right, of processing? And I think, but this is something too that you can also you can also use audit rights, creatively. I mean, you can also have a situation where if there are, let's say, violations of security requirements or potential issues where you thought there was an incident and you weren't notified, you could have escalating audit rights. Right. I mean, again, it's when you look at this holistically and when you are, and frankly, if you're just looking at the DPA, you might have audit rights. You should, in your regular agreement, your MSA or just your commercial agreement, there should be audit rights in there too, right? So potentially, so are those conflicting? Are they, do you need to map those correctly? So I just think.
Yeah, no, it's definitely an interesting one, again, to that point about context. And I like what you described. If you kind of go straight in and be like, I need to be able to do an on-site audit whenever I ask you to, that's very extreme. Let's be real. It's expensive for you, expensive for them. Like, is that really what you want to do? They're looking at that going, oh my God, what are they going to do to me? Like, what do you really care about? Kind of go back, what's your policy? Like, you should have an internal policy. Like, for our vendors that are high risk vendors or key vendors, we have our third party risk management policy is that we review them once a year, and that if they go through any sort of breach or incident that impacts our data, we'll do an on-site audit. Like, if you've got something like that, if you've really kind of spelled out that, then that helps you define, like, okay, what is the floor of what I'm comfortable with this particular vendor? Are they in this high risk key vendor bucket? And therefore I need to have higher audit rights. What I've seen is like, I want audit rights, and I'm like, this vendor is a one and done. Like, what? Like,
right. Why are we even fighting? Why are we wasting the ink?
Exactly. Yep. They agreed that's like a 1 month thing. They're gonna delete our data, and we're done. Like, then fighting over audit rights because it's in the template is not worth
no.
But I have seen where if you miss this entirely, you might be surprised. Like, let's say it's an older contract, you never signed a DPA, it's a different country, you inherited it through an M&A, and you're like, oh wait, we have no audit rights. And all you want to do is like, I just want to can I send you a questionnaire? Questionnaire. I've experienced before, we've seen before, those vendors like, nope, not going to sign it. Not like, so some like baseline stuff that can be important. At least you get the right to say, can I send you a questionnaire? And you agree that you will, fill out a reasonable questionnaire, or you agree that you'll keep your ISO certification and let me see, a copy of the official certification under NDA. And if that ever goes away, then I get to audit you. But those, the audit rights things can kind of go around in circles. And again, that's another one of those things, kind of reminds me of the security requirements. Sometimes you see like kind of almost on principle, I'm going to get the strongest audit rights possible. I'm like, in reality, is that really what you need or even plan on doing?
Right. Well, and it gets to, and you don't have this box on here, but it gets to sort of duration, right, of the agreement. And sure, you want to have, there's sort of competing interests, right? Because you want to have a long duration. Let's say, especially both, right? You would have, whether that's a vendor or processor or it's a customer, you want to have a long duration. You want to make sure you have a long runway for, but at the same time, you also want to make sure that you build in check-ins and the ability to modify terms or ask for changes if there are regulatory changes or changes in, right? And so that's something, it's not audit rights, right, but it's the ability to And it doesn't rise to the level of force majeure either, right? I mean, we're not, and so I think and I think that we honestly will be seeing more provisions like this, which
Mhm.
are fine. We agreed that this is a 3-year agreement, but and sometimes you see this, sometimes you see this laid out as like, we're going to have so and so from your side and so from my side, right? And we're going to form a committee, and we're going to sort of discuss changes as necessary, et cetera. I see more of that happening, honestly, in commercial agreements and sort of multiple areas. But again, I do think that given the way regulations are changing, given the political climate, given sort of geopolitical concerns, I think we will start seeing more of those mandatory or allowed check-ins and possible renegotiations of key provisions.
That is a really good
yeah.
point to highlight, Cynthia. And I'm glad that you brought it up. We are in a time of change where it is happening. Some of the changes are happening so rapidly that, what you want to have that ability to say, hey, we both can't predict the future.
Right.
But if the regulations change such that this relationship needs to be adjusted, maybe what you do is you just say, we agree that we will work in good faith to renegotiate to address those changing regulatory concerns. And if we can't we'll agree to part ways, or we'll agree to short, smaller early termination fee, or whatever it might be. I think it's a real point, because if you're working with a vendor and all of a sudden you can't reasonably figure out how to transfer the data to them because of a change in the geopolitical climate, the cross transfers don't work anymore. How do you get yourself out of that bucket where you're like, well, we want to try, and maybe both parties want to try. Can you part ways amicably if you can't find a way around it, or can you at least get everybody to agree, like, we'll try. Like, you can like, well, you have to just try. You can't just be like, well, too bad, so sad. Like, but you'll actually try to work with us. If, say, suddenly the EU won't let you transfer data to blah location where we've been doing that and we thought that was fine. And hey, because that could be a real operational burden on your vendor. They may simply not be able to say, oh yes, for you that this will be fine. And I can snap my fingers. So it's a good point to work in that ability. I think we've seen over the years where, like, oh, there's a new law. We're like, I'm sending you an addendum.
Right. We've all been through
you a different provision. But some of these other things could become more operationally more complicated to navigate by simply saying, sign this more paperwork. It's kind of more of the same with new words, kind of thing that you end up with. All right. Next.
Well, and even, to go back to that, even to the sending an addendum and saying, oh, here's an update to the terms, right? One of the things that we've struggled with a lot in the past is, does that count? Like, does your agreement actually allow for a one-sided sending of an update of terms? And frankly, I mean, I think now, hopefully agreements that are negotiated today do, but in the past they weren't, right? And so again, it's how do you bake in a certain amount of sort of extra flexibility and good faith in the negotiation of follow-on terms or different terms or a different type of relationship, or frankly, like you said, the ending of the relationship because something has changed that, again, doesn't rise to the level of force majeure. It's not, but it is big enough and important enough that what you've just negotiated is actually not going to work in practice.
Yeah, I think it's definitely going to become more important to consider. All right, let's get spicy.
Well, okay.
Do the privacy terms in the main agreement, privacy terms in the DPA? Fight. Fight.
Yes, you're right. You're right. Because it's true. We talked about this before. I mean, obviously, like the structure of is normally set up to have a DPA, an addendum, which is a separate agreement. But I think that if you're, and you probably still need that, right? But I am, again, because we go back to sort of my original pet peeve, which is like holistic contracting. I think that, again, if the data is important enough to you, and if it's, again, that's a sort of internal assessment of who you are as a company and what this agreement is, I think it's perfectly fine and advisable to double up, right, on those terms, meaning have those terms, the most important ones, in the main agreement, or at least make sure that you're tying it together so that it reads as one agreement, so that it's obvious, because oftentimes the DPA just magically disappears, right? So then you're like,
where'd it go?
is there a DPA? Seems like there should be a DPA here, but I don't find a DPA, but it needs to be obvious enough if the DPA is missing that there are terms missing. So you're not reviewing, 2 years down the line, or, so that you understand that you're reviewing an incomplete agreement. So
I think that's a good point. And this one is one of those where similarly, I like it. One of my pet peeves is when people think of the DPA as a sort of esoteric thing on the side that privacy team deals with and doesn't relate to the rest of the relationship. Whereas no, it should be flipped. If it's an agreement about data, that should be like the data protection terms are so key. It's not just the addendum. It's a key part of it. However, there's also that issue of like, from the perspective of making it easy to share, because sometimes the regulator is like, I want to see your DPAs, or maybe you're in a situation where you've agreed with a customer for them to see your DPAs with your vendors, and you really don't want them to see all of the commercial terms, but you can then rip that thing off the back and be like, here you go. So the upside, I know why we all have the addenda, because you can have, it makes it easier in some ways, but I do feel like, unfortunately, that structure, while practically important for certain reasons, does tend to inadvertently imply that it's just an addendum, or it's just this other thing that we tack on the back and it's not actually important, or that as important. And so I think that I'm of two minds about it. And yet at the same time, I'm like, yeah, we're going to have it as an addendum. Because I want to be able to here's the addendum if I ever get asked, without having to, redact half of the contract, being like, but what about these terms? I like what you said though, about making sure there's a reference to the DPA or the data protection terms in the main agreement, so that if you're pulling that agreement, like there's something missing.
Right. I think that's right. And again, they're just so often still today read as two separate papers. And the link between the two is hard to find.
Yeah. I've seen that too. And where you're like, there should be a DPA. I've also seen agreements where you're like, where's the DPA? And it's so buried. One vendor, I will not name names, we were negotiating with, was like, we need a DPA with this vendor. And everybody's like, I don't know. We never signed a DPA. Did we sign a DPA? And in order to find it, you went into the MSA, and then there was like set of defined terms. And in the defined terms, there was a security addendum. And in the security addendum, there was a DPA attached. It was so buried that I think we wasted so many emails and times and hours to be like, we need a DPA. Oh, we did have, I thought we had one. And before you know it, we like, finally someone who had been there at the beginning was like, oh yeah, you have to click 3 deep to find it. Don't make it that hard to find the addendum. Don't make it that hard.
And look, you know what? Go back to like your elementary school days when you were taught how to create a table of contents, right? Or a bibliography. I mean, again, right? I mean, look, that's important. You know, you have an agenda at the beginning of a presentation because it creates an expectation for what people are going to be, you know, what the topics are, right? And so why, again, these agreements are becoming more and more complicated, and there are more layers and there are more addenda that are structured in just in the first turn of the agreement, right? Just in the first iteration of the agreement. So make sure on page 1, there is some form of, you know, short table of contents at the top, which is like, you know, these are the pieces of paper that make up the entire agreement.
I like that idea. All right, I'm looking at the time being like, oh my gosh,
Yeah.
we're gonna stay all night. So really quickly, must-haves versus nice-to-haves. How do you figure out what's a must-have versus a nice-to-have?
I mean, you have to, like you said, you have to know your business, you have to know your data, you have to understand who you're dealing with, right? Like who's on the other side,
Yeah.
right? And have you benchmarked, and has there been an appropriate sort of like vetting of who that, you know, who that entity is and what they're doing for you? And then, but I think ultimately it's kind of like, it's what's your ethos, right? What's your ethos? I mean, you've talked about this in other contexts, right? But it, you know, that should dictate your must-haves and your nice-to-haves. But if you haven't done the exercise of understanding, you know, what it is that is, you know, what's a red flag for you may not be a red flag for someone else, right? And so, but that you've got to come to the table and come to an understanding of that in order to kind of build those out.
Yeah, I agree. I think that the thing that's important to also is flow downs. Don't forget your flow downs, right? As we talked about earlier, there's another party to the data agreement if you're talking about personal data, which is the individual. What are the obligations? And it might be your customer. There might be 2 other parties, your customer and their individual, the individual who's impacted. So those can be some of those must-haves. I know I have flow downs. So if you do procurement, know what's in your customer contracts. If they're talking about this, understand both sides. I think it's great to like cross-train for that reason between procurement and
Yeah. Oh yeah.
B2B kind of organization, or just like if you're a procurement, understand what's in your privacy notice. If you're a B2C client, so that you know like that's why it matters. That those are the must-haves. You also got to know your regulators, right? Like if you're in GDPR, know that Article 28, right? Know what your CCPA regs are about what's supposed to be in there, if that matters, if you're a service provider. I think those are the other ones that are easy must-haves. All right. We got to get to the topic. This is where I was like, we got to move on because we got to get to the topic. Contracting for AI. Sorry, Wayne's gonna be like, oh my God, this is gonna be another hour long. I swear we'll move through this quick because I'm sure.
Yeah. This is a top, has to be, this is like 10 hours. This is a whole, this is part 2.
Real high level though. Let's punchy. Like
yes.
what do you want to know? Like what are the high level hits for contracting?
Oh man. I mean, this is, and frankly, I think this just changed yesterday from a federal regulatory perspective. So that's a whole other client alert. But look, ultimately, whatever the regulations say, okay, let's be real again, which I'm not on that platform, but I've said that word a lot, but my children are. But look, what are the commitments? It doesn't change really. I mean, in the sense that like, what are the commitments you've made to the public, to customers with respect to your data? What is your sort of internal, like, you know, what's your kind of center of integrity or not with respect to the use of personal data and the use of data that you collect and where you get it? And build from there. I mean, I think the reality is that personal data, you know, data that goes into an AI training model is not coming back out. So just understand that. That's okay, right? So what does that mean to you from, you know, where you're sitting? And so again, right, what's your position in the supply chain, and what are you getting out of it, and what's the risk? And to your point too, Sheila, and I think the other thing here is understanding that the sort of why would a regulator care that you in particular, right, are using AI tools. And so understanding that as well, because it could be a different regulator from a data, a data protection perspective, and it could be for a different reason.
Yeah.
So again, just getting concrete, and evaluating the risk sort of from a high level, so that you have those guardrails in place. And then understanding your sales cycle and internally, right? Like, who's driving these decisions? Are these revenue, are these, so is it gonna, you basically, no matter what you say, it's just gonna go ahead. So you've only got like 5 seconds to give your high, I mean, right? You have to understand your business and who's making the decisions and calling the shots.
I have to say, like, to our point, where like we could spend so much time talking about all the different things that might come up in terms of buying AI, specific to data. So I'm not going to get into, because there's like, what is the AI model for? What are you using it for? Yeah. To your point, like high risk, low risk, like what does this mean? You might have to start asking your vendors, if you're using their products, like what kind of risk reporting are they doing? But focusing just on the data, I think one thing that can sometimes get not understood or fully understood is the difference between I'm using this model and it is training on my inputs versus it's not training on my inputs. What are the outputs? Is it training on my outputs? What's my outputs? And so some of that stuff can kind of get a little either overblown or like not addressed enough. So there's some, like, it's worth it to understand that the way that there's data that trains AI, there's data that is an input, there's data that is an output. The data that's an input could be PI, the data that's an output could be PI. It might not be PI on one side or the other. So where is in terms of personal data, where is the personal data coming into play? And if your inputs and outputs are also training data, then unless your vendor is promising that your model will only be used by you,
right,
model, they are a controller now. And so you have to contend with that issue. So maybe, you might be able to negotiate with certain vendors or ask them up front before you try to get all the way to the negotiation. If it's a big issue with you, if you cannot allow your inputs or outputs be used by another controller, then you cannot allow that vendor to use your inputs and outputs in a global model, meaning a model that they will then use with other clients. So it's important to understand, are we global model? Are we an individual model? Is it just my model? Like basically you're using my model, or maybe the hybrid model, which is they have a global model that's trained on maybe anonymized data. And then then based on that, that's the kernel of the model that gets trained on your inputs, but your inputs and outputs don't get used to train the global model. So there's certain things that just understanding and asking some questions can be really important around this, and honestly worth understanding AI a little bit so that you know what you're contracting around. And then to your point, like, what is it being used for? Like, what are we doing with it? Is it important? Because to your point, the data is not the only concern there, right? It could be it's not using any data, it's using anonymized data, it's not a problem at all from a data privacy standpoint, but it's driving a car. Okay, we've got some safety issues now, right? So the AI has a lot of issues that go beyond just the data issues, but focusing on those are the things that I think about. All right, final slide, some tips and tricks, some bullet points of takeaways. my takeaway, one of mine is cross-train your procurement and your commercial legal staff. I mentioned that.
Yeah.
That helps, particularly if you are a B2B, having that ability to give them context for the flow down issues. If they understand what our customers are negotiating with us, then they'll understand why we need to negotiate certain things with the vendors that are touching that data too. And so I think that can be just helpful for creating that context. Customizing required employee training to your business and risk profile. What does privacy mean to you that will retain it better? You mentioned the next one. I don't know if you want to grab that next bullet there.
Yeah. So, I mean, future proofing, right? And I think, and that looks different in different contexts, but again, how, everyone wants certainty. And obviously if it's a customer agreement, you want certainty of the revenue and you want to lock that down. But make sure that you are thinking about and that you're reading the news and keeping up to, and kind of applying that to your business and what's happening, so that you can future-proof in the right way.
Yeah, this is one where I think you see sometimes provision that says you agree that you'll comply with all applicable laws.
Yeah, right. See that all the time. Yeah.
Out there and say, however, if the laws change and I am not able to, we will negotiate in good faith to figure out whether we can do that, right? Because that could be that, yes, but maybe not as easy as straightforward as you think. And this is where I kind of go, don't be afraid to go back to the vendors and renegotiate if the laws change. I'll be honest, I feel like vendors at this point with GDPR and then CCPA and new laws, get it. Everybody else is asking for it. They probably, if it's that comprehensive or that impactful to their business model, they've probably figured out how to comply with that law, and they'll sign something to say, yes, I will comply with this one too, because it's core to their business that they need to be able to do that. And using those existing frameworks and templates, we said early on, these frameworks of controller processor,
yes,
strictly required is a very good way to start and give you ideas about like what are the contours of the relationship. I know we said like don't over rely on the templates, don't just sign them willy-nilly, but like they can be a nice helpful starting point to go like, oh yeah, I hadn't thought about that. I should make sure we talk about that in our agreement.
Yeah. And right. And I would say they're aspirational too, right? I mean, if you're not doing business in Europe today, well, I mean, I'm assuming the goal is to do business, in Europe eventually. And then it also, I would say on that one too, check in with your outside counsel, benchmark against your peers and your sort of peer groups as to, hey, do you have a scrubbed template that you can give me, or something that gives me a framework, updated diligence questions or sort of risk assessment questions, or different things, right? That are, again, keeping up with sort of how those are changing, and rely on your outside counsel like me or, or others in order to information share, right?
Exactly. You use the templates as inspiration, but don't be
a slave to
somebody else's. Don't be a slave to somebody else's template for sure. And understand the why behind why, if it's your own template, what's the why behind it? So that gives you that understanding of how to be flexible. And then kind of going to that same point, consider how the contract will actually work operationally, and getting back to that point about negotiating crazy sub-processor requirements or negotiating crazy security notice requirements. That it may not necessarily be better, and maybe you're fighting over something that's not really worth the time to fight for more. So again, kind of, I feel like the theme is understand the context. This is an operational this is a relationship, and we are setting up the terms of the relationship. What is it going to look like day to day if I have to comply with these rules? What does that feel like? It is not just, okay, we wrote a bunch of terms, we shove it in a drawer and hope we never see it again. These things impact the day-to-day relationship, and DPAs do get pulled out of the drawer periodically and get waved in your face if you're not following it. Yeah.
Agreed. And you know, I think, and again, because Wayne sort of put forth the challenge before we started recording about bringing in Maréchal Pétain into the discussion, which goes back to one of my first, what sort of when we talked about pet peeves, right? Which is survivability. And I think, look, data 10 years ago, no one talked about, nobody cared about, right? But data, data that is collected and the liabilities and the obligations around it survive. And you can try to limit liability, you can do all kinds of things, but if you possess the data, right, that the responsibilities that you have, whether those are to individuals or, you know, third parties, regulators, you know, whatever that is, right, it survives, which is my then, you know, my sort of tip my hat to our earlier discussion about Maréchal Pétain, who would never die, right? And everyone wanted him to die, and he didn't, and he survived. So if you can remember that funny little ditty, right, about again, it's you can't just sort of shove this under the rug and forget about it, right? These things live on and they have a separate life outside of the agreement potentially and the obligations that you, or the constructs that you've created. And I think that's the takeaway, is that this is becoming this is not just like it's not a liability that you can sort of carve away or a responsibility. It has lingering and long-lasting impacts on your business and potentially on your reputation and all kinds of things. So
yeah, I think that these things live on. These things live on, and again, I think that comes to the fact that like there is another party in the room, which is the individual whose data that belongs to. Particularly, we're talking about personal data. And again, it could be multiple parties. It could be your customer and the individual, but they are also in the room, and so be thoughtful about that. And then the context. These are operational constructs. They are not, oh, someday this might happen. It's not theoretical, and the deal isn't over when you sign the deal. Like there's
right.
To it. So I think with that. That is the end of our presentation. We could clearly carry on for a much longer time, but thank you, Wayne, for the opportunity for us to enjoy each other's company and nerd out together over privacy and contracting.
Yeah.
This is exactly the kind of program people want. It's practical, it's frightening, and useful at all the same time. So it works perfectly. I like it.
Excellent.
And we threw in a little bit of history. So
yeah.
You did.
People are going to be like, start Googling it. They'll be like, what?
Yes. There'll be an increase in sales from the 3 books that it sold before to maybe 10 now. Well, I want to thank you both for everything. It's been a wonderful time listening to you.
Thank you. It was a joy.
Thanks, Wayne.